afternoon, everyone. I'm Judge Lucy Inman, and presiding with me today are my colleagues on my right, Judge Fred Gore, and on my left, Judge Jefferson Griffin. A little bit less than a year ago, on April 30th, 2020, I presided in our first virtual oral argument session. And today is our first in-person oral argument session. And I find myself with the same tentative feeling of hoping that I will remember all the protocols to follow. And I just want to assure counsel that if you're feeling nervous about following all the protocols, you're not alone. And we will proceed and hopefully within a few minutes be thinking only about the case that's being heard and not about the trappings of the arguments. There are 3 cases that are on the calendar for oral argument, and they're all related. And they all come to us from Durham County, and the cases are entitled Tammy Lowrey versus Choice Hotels International, Inc., Manoj Gandhi, Mona Gandhi, Shiva LLC, Vibhai Lakshmi LLC, CI Hotels LLC, and WS LLC. And we have 3 different case numbers, which I want to get clear and make sure I'm understanding before the clock starts running on any of counsel's time. COA 20-649 was an appeal that was brought directly following the trial court's order in March, and it is related most directly, in my view, to COA 662, which was filed at the same time along with a petition for certiorari review. This court granted that petition for certiorari review, and because the issues presented in 649 and 662 are identical, as I understand them, but the court has granted cert review for 662, I will be referring primarily to that case. If there's something about 649 that counsel on either side think is different, let me know. Please let me know that. I will note that in 662, the record includes the order granting cert review. And so that's something that's different about that record. 20-782 presents the appeal by, I'll refer to them as the Gandhi defendants, and it includes, from my review, the most complete record. But I'm going to ask counsel to let me know when it's your turn to argue if you have any reason to want to point us to the record in one of these particular cases. Otherwise, I'm going to be looking at the record in 782, other than for that order granting cert. And if you need us to look at the record in another case because that's the record you've been looking at and preparing with, no problem. Just let us know and give us a page number, and it'll take us a little bit more time to find it. Have counsel, these are 3 cases, but we're not going to have 3 hours of oral arguments. And have counsel for the defendants decided how you want to split up your time? And I guess I'll go ahead now before we're not running the clock against you, but just ask counsel if you're ready to proceed and introduce yourselves. And you may take, I should have done this. You can take your mask off when you're talking, and if you can't understand anything that I'm saying or one of the other judges saying, and we forgot to take our mask off, please tell us.
Thank you, Your Honor. Chris Skinner here for Choice Hotels International. Josh Nabors, secretary of all the rest of the Gandhi defendants. And we had initially planned to split the first 25 and asking for permission to rebuttal for the last 5. I think we were under the impression that it was 30 minutes total for all of us, so we had sort of
Okay.
decided to tackle it that way, not knowing sort of how we were going to handle the reappeal, sort of how. And I agree with Your Honor, the 2 of us are married to each other.
Okay, so the 2 of you are figuring out how you're sharing your time, and is 25 as usual and then 5 for rebuttal?
Yes, Your Honor.
Okay.
And Scott Gallagher is associate lunch is here for on that record you just talked about. I just wanted to introduce her as well.
Great, okay. And for the plaintiff, of course, I recognize all of plaintiff's counsel. So glad to have you here, but if you can let us know how you plan to split it.
I'm Harvey Kennedy, and I will be doing all of the argument for the appellate. And proceed next to me is Harold Kennedy III, our law partner, Charles Francis, who's our co-counsel, and Ruth Shee, who's our co-counsel.
Well, you've got a strong bench. And are appellants ready to proceed?
Good afternoon. Again, may it please the court, my name is Chris Skinner from Yates, McLam & Wire. Myself and Josh Nabors represent Choice Hotels International only in this matter. Like I said earlier, Mr. Tierney represents all the remaining defendants. First, I want to sort of apologize in advance. This is not only my first Court of Appeals hearing, the first live hearing in maybe over a year, so I suspect there's going to be a fair amount of nervousness and rust on my part. So I will try my best.
You're in good company with all of us.
So, as Your Honor mentioned earlier, we're here on a writ that we filed and an appeal from a March order. They are very much married together. The sort of how we got here is very convoluted and a little bit confusing in terms of the hearings and the orders and everything that was done. And I'm certainly glad to discuss any and all of that, but my initial plan was to sort of concentrate on the Durham being a proper venue issue. I believe that the writ's purpose is to sort of correct those wrongs and get us to discussing a substantial right as the venue issue. And so, my hope is, and again, I'm glad to answer any questions about sort of what happened in those hearings. It's very confusing and convoluted. Again,
If I could just ask you, if
Yes.
if we resolve the cert case,
yes.
2662 on the merits, which places both the December and the March orders before us on cert review, would that completely resolve the issues in 20-649?
Yes, Your Honor. We followed that one out of the abundance of caution, given that had just
Thank
happened.
you.
So, right.
Very well. Thank you.
So with regard to the proper venue issue, we believe that the issue we're here today is, what we believe is a case of first impression, and that is sort of this idea that a franchisor like Choice Hotels International, by merely and solely lending their brand name to an unrelated franchisee in an unrelated county, can be established as having venue or jurisdiction in that particular county, without any other tie to that particular county. I think the parties sort of agree on a few things. One, the plaintiff resides in Johnson County. The Gandhi defendants all reside in one way, shape, or form by virtue of their companies or themselves individually in Johnson County. Choice Hotels International is a domestic corporation with a registered office in Wake County. I think we all can agree on that. And so the question is, does the statute extend, the venue statute 179, extend to allow a plaintiff to go to outside of those Johnson County, Wake counties and go to another county because there is some sort of, as the plaintiffs would put it, some sort of business interest in that county?
If I can ask you, as I understand the timeline, there was a hearing in December. Both Choice Hotels and the Gandhi defendants filed answers that included within the answers motions to change venue. The plaintiff noticed hearing on the Gandhi defendant's motion to change venue, on plaintiff's motion to amend. No one noticed Choice Hotels' motion to change venue. The hearing happens December 2019, and I don't know if it was you or Mr. Neighbors or other counsel for Choice Hotels was, in the hearing, and I understand your argument that there was no motion nothing was set, nothing was scheduled, the calendar set. When counsel for the plaintiffs started making representations to Judge Hudson about Choice Hotels owning and operating properties in Durham, did counsel, and I understand your motion wasn't on the calendar, and I'll also say that I practiced law for many years before I became a judge, and like every other lawyer on the earth, I was not perfect. And I had a lot of coulda, shoulda, woulda. Why did not counsel say, stand up for your client to say, where's this coming from? I don't know this.
So I think that's a very good question, Your Honor, and I think the way to answer that is to back up a little bit, if it's okay.
Yeah.
The complaint in this matter never raised the issue of owned and operated. They were very clear about this idea that we maintained or really had business interest in Durham County. That's all the complaint says. And it also mentions Terry v. Cheesecake case as a way to establish jurisdiction. But
Well, there's but then again, the same question,
Yeah.
question. They're arguing about Choice Hotels' business relationships in Durham, and is it a strategic thing to wait and take another bite at the apple later?
Well,
in another motion to change venue? What's the?
and Mr. Neighbors is there, I hate to speak for him, but what I would say for him as someone who does what he does and is a colleague of his, I do think that would have constituted a waiver at that point. They brought up issues at that point that had never been brought up before. They had an affidavit with internet printouts, and then they argued we owned and operated those that were not in the affidavit. So, not to speak for Mr. Neighbors, but what he should have done is not said anything and done exactly what we did do, which was get an affidavit from our general counsel saying, no, that is 100% not the case. We do not own and operate anything in Durham County. So I think it was a tough situation because, the argument initially against the Gandhi's defendants that was anticipated for that hearing was they had investment property in Durham, but I think they realized that ain't good enough and they switched trains at the hearing.
And I don't want to necessarily take up
Yeah.
your time with that,
Sure.
but just understanding that makes it more confusing. And then I think it was within 2 days after this hearing that Choice files an answer to the amended complaint that says clearly, do not own or operate property in Durham County.
Yes, Your Honor.
And then the general counsel's
Affidavit.
affidavit comes in January.
I think that's right. I don't have.
Okay,
Yes.
Sorry
yeah,
to interrupt.
Yes, I think that is the train of how we got here. And then, of course, the March hearing, we took the position this was our first bite at the particular apple. Judge Hudson, on the record, said, in court, and the transcript said, I'm denying your 12B3 and your amended answer because Durham is a proper venue. But in the order, he just said, I'm granting the plaintiff's objection to hearing anything. So it was very confusing, and we were left with sort of, that's why we filed the writ. We felt we were left with really no option. He was not allowing us, we felt, to have any hearing on venue. And, again, when I asked him what he was denying that day, I thought I had enough, to then appeal the March order because he was actually denying a substantial right on venue, and then he refused to put it in the order, even after I sent him the transcript and asked him to merely write the order as the transcript said, and he just sustained an objection to having anything heard at the hearing as part of his order. That's not actually what happened.
and then what authority does the Court of Appeals have to second-guess Judge Hudson's determination in the March order that he believed that he had resolved all the pending motions in December?
Right, and I think that's going back to December, and that is part of the writ, which is, as Your Honor said, it was noticed, it was part of the calendar, but even the hearing itself, it was the only thing that was discussed and it was the only thing brought about. But then when the order came out, there was, the apostrophe was taken from the inside of the S to the outside of the S. And so, I approached Judge Hudson about that and said, Your Honor, you clearly said the only thing we're hearing is the Gandhi's motion, and despite being shown the transcript, he said, well, I thought I was hearing everything. So again, that's why we filed the writ, because everything was just very, very confusing, and we felt like we were not getting any chance to argue any portion of the venue statute, which is a substantial right. So we felt that our only choice was the writ. Was the writ option, because we felt that substantial right was being affected by virtue of not ever getting to be heard on the issue.
And then your appeal from the March order, is this a Rule 54B motion? Is this the plaintiffs have pointed out that, and I guess, and the December order, the plaintiffs have pointed out that there's a time limitation on a Rule 60 motion. As I understand the rules, the time limit on a Rule 54B motion is until final judgment's entered.
Correct, Your Honor. And again, the hearing got very confusing. If you read the transcript, we moved for the 54 and a 60A motion, which was to ask the court whether they had an apostrophe issue, and the plaintiffs argued it's a 60B, and Judge Hudson agreed there was a 60B, but nobody had moved for a 60B. So again, it gets very convoluted, and the soup, it starts to get really mucky and hard to understand, which is, sort of why we resorted to the writ, because, our hope was this panel could help clear things up or help understand or address the substantial right regarding the venue issue.
Okay, very good.
And I'll skip down a little bit, down on my outline a little bit. I believe the standard of review for these matters is de novo. I do think there were some parts of the plaintiff's brief or the appellee's brief that says abuse of discretion. I don't think that holds water here. I believe, as Justice Inman indicated, the order says that it was the motion, the Gandhi's motion was denied because Durham was a proper venue based on Terry v. Cheesecake, which has nothing to do with the convenience of witnesses. Convenience witnesses argument would be the only one that's an abuse of discretion. It's clear whatever order or whatever Judge Hudson said in court, it was deciding that venue was proper in Durham based on Terry v. Cheesecake and not some sort of convenience of witnesses theory. So I wanted to address that up front.
And what about the standard of review of Judge Hudson's March order? And it is, I cannot remember if the March order even refers to Rule 54.
If it does,
It does, and it says that, yes, it says that Rule 54 cannot be a substitute for appellate review, cites the Jenkins case, which I believe is about Rule 60, and having failed to give notice of appeal, defendants are not allowed to collaterally attack said order.
I believe Rule 54 is an abuse of discretion, but I don't know that we get there because he never heard us on any of those. He basically, the order says he objected to even hearing us on any of those motions. So they were never denied per se, they were refused to have been heard.
Well, there are different ways that
Sure.
courts can abuse their
Discretion.
discretion, and, one is a misapprehension of law, one is to, and to not exercise discretion.
And our behind our Rule 54 was this idea of erroneous information was given by Mr. Bibbs, who was acting as plaintiff's counsel then. He got up and said Choice Hotels owned and operated 5 hotels in Durham. That was clearly not true. The plaintiffs admit in their brief that that was a mistake or erroneous information. So that would have been the basis for our Rule 54. But yes, Your Honor is correct. That standard of review is abuse of discretion. So to sort of fast forward here, I don't think I have much time left on the original plan. To sort of jump to the venue portion, if I can, Your Honor. 1-79 is what we're dealing with. It is how we determine proper venue for domestic corporations. Part 1 is just where your registered office is, which is clearly Wake County here, and then Part 2 is maintain place of business. I think that's where we stop and where we sort of disagree here. Obviously, prong 3 is if none of those, then this, which is a carrying or engages or carrying on in business. The plaintiffs in their brief are asking this court to determine that maintains a place of business means a traceable and connected business activity or simply having business interest. That seems to be a pretty far stretch from maintaining a brick and mortar place of business. I think it fails on several forms. One, merely plain meaning, a place of business. You have a place, you rent a brick and mortar location, you have chairs, you have furniture, you have fixings, you have employees. That's a place of business. They're asking you to say any traceable touch in any county maintains a place of business. In addition, the framers of the statute were very clear in how they carved out that exception. If they meant for conducting business activities to maintain place of business, they would never had to put number 3. They could have stopped at prong 2 and not gone that far. And lastly, I think the overriding concern that my clients have, and I personally have, is the ramifications of completely overhauling our venue statute to say maintain a place of business is this traceable touch in any business activity. The most harrowing example would be, Joe and Susie's Widget Farm in Nash County. They maintain a farm and a business there, but they may sell to several farmers markets around North Carolina. Well, plaintiff has an incident at that farm, local plaintiff, local owners, incident happened there. Under the plaintiff's theory, they can go reach any of these counties in which the widget farm sells goods, and they can be subject to venue there. And we then become a very form selection state. You know, we're opening Pandora's box to become on the forefront of form selection on counties, and I don't think that's the framers of the statute 1-79 were looking to do. They weren't looking to provide legal loopholes for form selection. They were looking to properly identify where these cases should be. You know, anyway, in conclusion, I don't want to give Mr. Tierney's time, but I think at the end of the day, if this court decides to move it to Johnson County and Wake County, which are both proper venues, and we would be fine or consent to both, either one, the plaintiff is not prejudiced here. They're not in a worse place. They still get their day in court. They still get to try a case. They get to try a case, the plaintiff gets to try a case in their own backyard where family and friends live in Johnson County or Wake County. But this court still gets to preserve the substantial right of the defendants to have the case tried in a proper venue, and I do think that is important. Thank you.
Thank you very much.
Sorry, Greg.
May it please the court, I will hustle here. I don't have much time. We have 5 minutes reserved. I'm Craig Tierney. I represent what's collectively the Gandhi defendants in this matter, along with Skylar Gallagher. What I would like to do is first say that only MM Shiva LLC is the franchisee for Choice Hotels. None of the other Gandhi defendants, either individually or the other two or other three LLCs, have any legal relationship with Choice Hotels. What we are here today on for the Gandhi's motion is review of the March order, which was a Rule 54B motion for reconsideration. We had also moved for Rule 60 as well as Rule 54B, but we now know after the Doe versus City of Charlotte case that this court put out several months after our March hearing an excellent decision that advised litigants that Rule 54B is the correct procedural method to do a motion for reconsideration in North Carolina. So we did move for Rule 54B, and we are here today on the appeal of that order that was denied by Judge Hudson. What I would like to do is talk about Rule 54B. There is no checklist in the rule itself as to what hooks you have on a Rule 54B on reconsideration. There's really no guidance there. Actually, plaintiffs, in their brief, they found a North Carolina business court case, that's the W4 Farms case, that looks at federal rules, because federal rules are a little more developed on Rule 54B, and not all of those standards, but some of them, a couple of them I want to address, is discovery of new evidence and the need to correct clear error or manifest injustice. Correct clear error or manifest injustice. Let me talk first about the clear error and injustice. The underlying issue here on all of these appeals is all of these parties at the commencement of the action, where did they reside? And where is the proper venue at the time of the commencement of the action? All of the record evidence we now know shows that all of the defendants, including the plaintiff, including the LLCs, including the Choice Hotels franchisor, resided not in Durham County. I agree with Choice's statutory analysis, and it was more developed in the brief. We're here on limited time, but it's more developed in the brief. But that statutory analysis of 1-79 is critical to this case.
And you can assume we've all read the briefs, and you don't need to repeat that.
Okay, so we agree with that. We agree that they were a resident of Wake County because they had their registered place of business there. Now, newly discovered evidence. Our first bite at the apple, our motion, was at December 12, 2019. I think a review of the timing is important here. We filed our amended complaint along with our motion to change venue. We filed that on October 17, 2019. Now, 2 weeks later, The plaintiffs noticed our motion to change venue. Now, that is irregular. It's not improper, but it's irregular for a plaintiff to notice a venue motion of the defendants. So with 2 weeks, that was noticed, and the hearing was on December 12th. There was no discovery, no depositions prior to that December 12th hearing. Mr. Bibbs noticed the motion only for the Gandhi defendants, and that is clear in the record, it's clear on the calendar, and it's clear when counsel introduced the motions to the court. I stood up and said, this is my motion to change venue, and Mr. Bibbs said, we agree. That's what we're here for. So we agree with Choice that they were not properly noticed on that motion. Now, during that hearing, I did not have the benefit of this affidavit, which came in later after that motion. After Choice heard the words about own and operate, they got their general counsel, then they filed that affidavit. I did not have the benefit. My clients did not have the benefit of that in December. So we did not press the motion for proper venue because under the Cheesecake case, I improperly assumed that that applied. We pressed the convenience of witnesses. Now, they have raised issues of waiver and admissions about not pressing that proper venue motion. We did not waive or admit that proper venue. We filed that motion for proper venue in our first answer. We filed it in our amended answer. We filed it in the answer to the amended complaint that was filed after the December hearing. So even after the order, we continued to press the proper jurisdiction. And of course, we filed that motion to reconsider. We also filed a writ, which this court denied, but we did appeal that March 3rd order. So we have been pressing this the whole time. That is the newly discovered evidence, and we think for these two reasons.
So the newly discovered evidence, again, just so I'm clear, your position that the newly discovered evidence is that what?
Is that Choice Hotels did not own or operate any hotels or any business in Durham County. Okay. And we now know, the record evidence is clear, that when Mr. Bibbs proclaimed in court and filed the affidavit with the court that they did own those businesses, that was in error. Now, that also could carry over to Judge Hudson's ruling on the convenience of witnesses when he's hearing that there's 10 hotels that a co-defendant owns in Durham. So I do have some concerns about that as well.
If I could just ask you, you make a point in your brief that the plaintiff's allegations that the Gandhi defendants have all sorts of business activities in Durham is irrelevant with respect to the individual defendants.
Correct, Your Honor. The statute says reside.
But as to the corporate defendants?
There is no record evidence or affidavit that they owned any property. Okay. Those properties, the affidavit was only for individuals. And standard review, real quick, I'm just going to say on standard review, we cited the Diggs case, which actually the Kennedys were involved in, and we think that because the underlying motion was a substantial right, a question of law, that it is a de novo review, it is not abuse of discretion on the Rule 54B. And my time is up. I'll answer any questions, or otherwise I'll yield to plaintiff's counsel.
Great.
Thank you.
Thank you.
Mr. Kennedy, we'll hear from you now.
Yeah, thank you. May it please the court, I'm Harvey Kennedy, and to begin with, I want to make a critical point which is dispositive of all three consolidated appeals, and that is that all three of the appeals are now moot. All three of the appeals are now moot. Let me explain what I mean by that. In the reply brief of the Gandhi defendants at page 9, in case number 20-782, they cite the case of Lending Tree LLC versus Anderson, this court's decision in 2013. This court in the Lending Tree case held at page 410, when defendants participate in discovery, they waive their venue objection. When defendants participate in discovery, they waive their venue objection. Within the last few weeks, the Gandhi defendants filed a record on appeal in Court of Appeals number 21-199. That would be the fourth appeal in this case. And this is an appeal from rulings concerning discovery disputes in the trial court. The record on appeal in that case shows that the Gandhi defendants served plaintiff with their first set of interrogatories and requests for production of documents on October 31, 2019. That is found in the record in that new case at page 94, entitled Exhibit A. So what we point out to this court, the recent filing of that fourth record on appeal in the same case that we're dealing with today, establishes that there was a waiver of the venue defense which occurred on October 31st, 2019. Second, in the record on appeal in this case, at the December 12th hearing, Choice Hotels Counsel had the plaintiff's attorneys to sign a protective order so that they could produce a franchise agreement under seal. Again, that's part of discovery as well. And so that was on December 12th, right after the hearing. On February 24th, there was a hearing on the motion for reconsideration in this case. There was a hearing transcript, and in the hearing transcript at page 40, there's a reference to a May 11th trial date. At page 44, there's a reference to discovery deficiencies, which defendants counsel argues that the plaintiff had discovery deficiencies. On page 78 of that transcript, counsel for the Gandhi defendants made a reference to outstanding discovery. At pages 82 to 83, defendants counsel had discussion of discovery disputes and pointed out that the deposition of Mrs. Gandhi would occur that afternoon on February 24th, the same day of the hearing, and the hearing on reconsideration, and that the deposition of Mr. Gandhi would occur on February 25th.
Mr. Kennedy, if I can, and I don't mean to interrupt if there's more instances of waiver that you want to receive.
No, this is it. I just want to summarize. Yeah.
So I understand that, in dispute here is the venue of the trial.
Yes.
Venue of the trial. And I have not studied the Lending Tree decision and your argument on mootness?
Yes.
As a practical matter, if it's true that the defendants waive their venue objections by participating in discovery and taking in discovery, then this case should have just been frozen in time from the moment of the appeals being filed? And, I mean, is that what they would have needed to do, in your view, to protect their appeals, would be to take no discovery, and could they refuse to respond to discovery requests by the plaintiff as well?
No, I think what should have happened, Your Honor, is that any time you're a defendant and you move for a change of venue, then you need to immediately, or in a short period of time, calendar the motion for hearing. You recall in this case, the motions for change of venue, which were in the initial answers, it was almost 2 months before there was a hearing, and the hearing only took place because plaintiff's counsel calendared the motions. Defendant's counsel made no effort to have a hearing on their motions for change of venue. But what I'm saying, Your Honor, is that the discovery in this case, at least the initial discovery that we could find in the record, in the new record on appeal at page 94, is that the initial discovery from the defendants was dated 10/31/2019, which precedes the time of the court's hearing in December. So when you're talking about what should have been frozen in place, I think actually once there was an appeal on the motion for reconsideration, I believe at that time that pretty much stopped any further discovery on that second appeal. But what I'm saying is that they started conducting discovery prior to the time that there was the initial hearing from Judge Hudson in December.
Did you consider filing a motion to dismiss these appeals as moot?
No, I did not, because in preparing for the arguments here today, Your Honor, we, of course, went back and read the recent reply brief of the defendant Gandhi's and stumbled across that case, the Lending Tree case. And when we went and read the Lending Tree case, it was obvious that this case would have to, the appeals would have to basically go down because of mootness. And of course, we believe that the law is clear from this court as to what the effect of pursuing discovery is. Again, as I point out to you, that discovery was started prior to the time that Judge Hudson ever had a hearing.
I see. Okay.
Let me move on, if I could, Your Honor. I want to also point out that a threshold issue
And
is
Mr. Kennedy, if I can just, because I'm afraid I'll forget it, just to say right now, not having seen this issue raised in the briefs before and in a motion to dismiss, I'm going to be catching up with counsel's argument and thinking about that and understanding about that. And we may invite counsel to submit supplemental briefing on this issue.
okay. Thank you very much.
Thank you.
If I might, a threshold issue in this case is the standard of review. The defendants appeal from the trial court's order denying their motions for reconsideration under Rules 54B and 60 of the North Carolina Rules of Civil Procedure. Their joint motion was entitled Motion for Relief from Judgment or Order. Defendants argue that the correct standard of review is de novo review. That is clearly wrong, we contend. North Carolina law is pellucidly clear that the correct standard for review for an appeal denying a motion for reconsideration under Rule 54B and Rule 60 is, quote unquote, an abuse of discretion. We point out in our brief there are two major cases on Rule 54. And those cases are W4 Farms, Inc. versus Tyson Farms, Inc. from the North Carolina Business Court, and Akiva, LLC, v. Adidas from the U.S. District Court for the Middle District of North Carolina. And those cases make it clear that the standard of review is an abuse of discretion. The same thing is the law from this very court on Rule 60A and B in the cases of Buncombe County by and through Child Support Enforcement Agency, X-Rail Andrews v. Newbern, and also the case of Pope versus Pope, makes it clear that under Rule 60A and 60B, they are subject to an abuse of discretion standard. And as you know from the important case from this court, Manning v. Anagnost, this court held that in order to meet the standard of an abuse of discretion, the trial court's ruling must have been so arbitrary that it could not have been the result of a reasoned decision.
Mr. Kennedy, if I can just interrupt you right there, are you aware of decisions from this court and the North Carolina Supreme Court holding that misapprehension of law by the trial court can also be an abuse of discretion?
I think it had to be more of a manifest injustice, I believe.
If I would just look, if we look at Judge Hudson's order, the March order,
Yes.
which concluded that the Rule 54B motion was untimely and cited Jenkins versus Richmond County. Isn't it true that Jenkins versus Richmond County did not involve Rule 54? It was a Rule 60 case?
I think you're correct there, Your Honor, but I don't believe that Judge Hudson was wrong in his order because of the fact that he went on to say that the defendant's motion and amended motion for relief from judgment of order in the court's discretion is hereby denied. So his decision was also based on the court's discretion. And, Your Honor, I would say that there's no entitlement to some type of a correct, there's no entitlement to a favorable ruling on a motion for reconsideration. The trial court can simply reconsider, and he can also deny the motion. That's what happened here. He had a hearing, he listened to the arguments of counsel, and he denied the motion. And as he also pointed out in his order of what had happened previously in December of 2019. So I would say, again, the court had discretion.
Very well. And so in other words, because this concluding paragraph says, in the court's discretion,
Yes.
this is evidence in the record you would submit that the trial court did exercise its discretion.
That's correct.
And didn't misapprehend the law and think that it couldn't, that it did exercise its discretion. If this court were to find error in Judge Hudson's December order,
Yes.
what effect would that have on Judge Hudson's March order?
Well, I would argue that it has no effect because those are separate motions. The motions before the court in March were motions for reconsideration.
But in other words, if this court were to reverse Judge Hudson's December order, if this court were to reverse Judge Hudson's December order, wouldn't that render the March order moot? or void? In other words, if the underlying order that the defendants unsuccessfully asked Judge Hudson to reconsider were overturned by this court, does it really matter what Judge Hudson did in March?
Well, maybe you're right about that, but my argument would be that this court should not reverse Judge Hudson's December order, as his order makes very clear that after reviewing the material submitted by the parties and the arguments and authorities presented by counsel, the court in its discretion and based in large part on Terry v. Cheesecake Factory, finds that venue is proper in Durham County. So if I can, let me address those arguments quickly to show why Judge Hudson's order was not incorrect. I would point out before we move from the last argument that the issue on the second issue on reconsideration, again, the standard is abuse of discretion, and defendants have not even argued there was an abuse of discretion. The second major point is the question of the appropriate venue for this action was properly before the trial court at the time of the December 12, 2019 court hearing. Both sets of defendants filed motions for change of venue in their answers. They all contended that venue was improper in Durham County. This venue issue came on for hearing on December 12, 2019, and the amended notice of hearing dated October 31st, 2019 was properly served on all defendants' counsel in this action. I know that it says in the title, defendant's motion with an apostrophe S, but the motion was served on all defendants' counsel. And of course, all defendants' counsel appeared for the hearing.
Sure. If I could focus you, just because I want to make sure that you have time to answer some questions that I think I have. If you look at the merits that were in dispute in the December 2019 hearing, do you concede, as your client's briefs concede, that Mr. Bibb's statement to the court in December 19th that Choice Hotels owned and operated properties in Durham County was incorrect?
Well, I think it would be maybe incorrect to say that they owned, well, let me back up a second. No, I think the correct answer is that issue, Your Honor, is conflicting and inconsistent. And let me point out what I'm talking about. At the December 12th hearing, there's a plaintiff's affidavit of December 10th, 2019, which lists an Exhibit A.
Yes, that's Ms. Lowrey's affidavit with various properties
It
listed
lists
from the
8
internet.
choice properties. Now, there was an affidavit filed, this was on the motion for reconsideration, by Stuart Kreinler, an assistant general counsel for Choice. And then Stuart Kreinler later, before the hearing, files an amended affidavit. And in the amended affidavit, if you look at paragraph 6 of that amended affidavit, it says the following, quote, as of the time of the filing of plaintiff's complaint and amended complaint, and continuing through the present, Choice Hotels did own these properties. That's exactly what that affidavit says in paragraph 6 of the amendment.
That's on page 230 of the record.
Look at paragraph 6, Your Honor, of the amended affidavit, which states, as of the time of the filing of plaintiff's complaint an amended complaint and continuing through to the present. Choice Hotels did own these properties. Do you see that?
I do see that.
So I would say that Judge Hudson could have certainly relied on that, and certainly that would be consistent with what Mr. Bibbs argued. But just giving the defendants the benefit of the doubt, the best you could say for them is that the evidence is conflicting on that point. It's inconsistent, so it's not a basis for them getting this reversed on a motion for reconsideration.
Sure. And have you, as you stand here today, you would not concede, is what you're saying, that Choice Hotels does not own any properties in Durham?
I don't concede that. I think we have to rely on the sworn affidavit of Mr. Cronler at paragraph 6 of his amended affidavit. And when you file an amended affidavit, you're replacing the original affidavit, right? That's what you do when you file an amended affidavit. You make a correction. That's what he did. So no, we don't concede anything. But what I would point out to Your Honor is a couple of things. You ask a question to defendant's counsel for choice. Well, why didn't the defendant's counsel say something when this motion came up? Remember, at the time that the motion was called for hearing, Judge Hudson had each of the attorneys stand up and give their names and the names of their clients, and all the defendant's counsel did that after this motion had been called. I point out to you that no defendant objected to the hearing of the motion to transfer venue. None. So when this motion was called and defense counsel says, well, I'm not sure what was going on here, as you said, well, why didn't you stand up and say something? Well, he made a decision to remain silent, but he should have objected to the hearing if he felt there was some type of irregular notice. No defendant moved the court for continuance of the hearing. And what is the law in North Carolina? It comes from this court. The case of Nicholson versus Jackson County School Board. In 2005, this court said as follows: by failing to object at the hearing and by failing to make a motion for continuance, that the defendants waived any objection.
But again, defendant Choice Hotels has argued, and the record, on its face appears to support the argument that Choice Hotels' motion to change venue had not been noticed for hearing. Choice Hotels' lawyer was there, and yes, we can ask the question why, and Mr. Skinner offered one concern, that there could be waiver from speaking up, but if it wasn't Choice Hotels' motion that was being heard, why was it the obligation of Choice Hotels' counsel to ask for a continuance?
Well, first of all, I disagree with the way you characterize that, in all due respect, Your Honor, because the motion said it was on defendant's motion for change of venue, and it doesn't spell out in the calendar request that this is defendant Gandhi's motion. It just says defendant's motion. So that could have been any defendant.
Okay, so you're saying
right?
that the plaintiff's notice did give notice.
I'm saying it did give notice because it didn't say in the notice of hearing, this is just for the Gandhi defendants. And recall, the Gandhis, I think there's 7 defendants. So that would be correctly, if you were noticing it, you'd say an S apostrophe for the Gandhi. They got 7 defendants, whereas Choice is the only single defendant.
Well, no, in other words, if there were multiple Gandhi defendants, then you would have an S apostrophe even without Choice Hotels, right? Grammatically?
Yeah, but again, it says defendant, so if there's a question about it, if it's not clear, then what the case law says is you come to court and you raise an issue. As you brought this up, you just don't sit there silent. The other answer to your question is this. The court only rules on the issue of proper venue, whether venue is proper in Durham County. The court's going to rule on that one time. This is not a situation in a multiple defendant case where one defendant can come to court and have the court rule on that legal issue, and the other defendant stay silent, then go before another judge, raise the exact same issue, and say, well, forget about what the first judge did. We can have our own. So all these people in it together. As the case law in North Carolina is that if venue is proper as to one defendant, it's proper as to all defendants, because in the case law dealing with venue, all multiple defendants are in this together. This is not a situation where one can go and have an argument and have a decision on a legal issue of whether venue is proper in Durham County, and the other one go to another judge or wait for another day to make the same argument.
So they each had separate motions with an S.
Yes.
But what you're arguing is, as a practical matter, we're not going to have venue for one defendant here, one defendant there. But isn't the law that the plaintiff has to, when challenged, has to show that venue is proper for all the parties?
No, just one.
Just for one?
The law is, and you'll see it in our brief, there's a whole page and a half on this issue in our brief. We just have to show that venue is proper as to one of the defendants. And if that's the case, then as a matter of law, then venue is proper as to all. Let me move on.
Mr. King, will you concede that the plaintiff drafted the notice? You said the plaintiff had to draft the notice of hearing, is that correct?
Yeah, that's correct.
Okay, I mean, so if any ambiguity, it was in the notice itself, in the calendaring, it would be on the plaintiff, correct?
No, because if there's ambiguity, then as this court said in that Nicholson case, you've got to raise the issue before the trial judge. You just can't sit there and remain silent. So defense counsel could have said, Your Honor, I'm not sure whether we're even supposed to be here, or if you're going to decide this issue today as to whether venue is proper in Durham County, then we need to continue this matter to give me more time to address this. A lot of things could have and should have been done. So I would say that when you ask the question about all defendants, we cite like a page and a half in our brief that venue just has to be proper as to one defendant. Let me move on. I know the time is moving very quickly, but I do want to point out that with respect to the issue of place of business, venue, the standard is a place of business, maintaining a place of business. Defendants counsel argues without any legal support that the plaintiff would have to show ownership, that they owned these hotels, and we say that's wrong. Merriam-Webster Dictionary defines a place of business as a place which business is done. And we say that the standard, the legal standard, is set forth by this case in Terry v. The Cheesecake Factory, where this court held that the plaintiff met the test of proving a place of business by establishing that the defendant conducts business activities in Durham County. And the court also pointed out that the defendant in that case also owned some equipment, fixtures, and furnishings. We contend that the plaintiff meets the standards set forth in Terry for the following reasons. First, the franchise agreement of Choice Hotels, which was produced in discovery and has been filed in this case under seal, clearly shows that that standard is met. One, Choice owns by the agreement. Choice owns all the intellectual property rights that cover any franchisee hotels, including brand marks, choice marks, or reservation system. Choice owns all intellectual property. Second, any hotel data is owned jointly by Choice and the franchisees. Third, Choice requires all of its franchisees to participate in its discount and promotional programs. Fourth, Choice requires referrals by franchisees to other Choice hotels. Fifth, Choice requires all franchisees to purchase general liability insurance of up to $1 million. Finally, I would point out that Choice exercises significant control over its franchisees, and I would ask this court to read the Fourth Circuit's decision in the case of Crinkley versus Holiday Inns, Inc., which is a 1988 decision from the Fourth Circuit, pointing out that in a franchise or franchisee situation, that you look to see whether the franchisor exercises significant control over its franchisees. And you look particularly at the franchise agreement. And that decision, the Fourth Circuit rendered a very favorable decision for the plaintiffs in that case. So I would argue to the court that Judge Hudson's orders should be upheld on appeal because these are discretionary motions.
And just to make clear, and I know you're out of time and I'm adding to it because I'm asking you a question, your argument is if Choice Hotels owns or operates any hotel in Durham County, any hotel in Durham County for the reasons you've just stated, that venue is proper in Durham County.
Well, I'm not even talking about that. What I'm saying is if Choice maintains a place of business in Durham County, then venue is proper. Not if they own real estate or own or operate, but if they maintain a place of business in Durham County, and they do that through the franchise agreement.
So you think a franchise agreement is a place of business?
The franchise agreement by itself is not, but the franchise agreement establishes certain relationships between the franchisor and franchisee, which would be sufficient to establish a place of business.
Okay, thank you.
And would it be that nexus that you're arguing of their control of those franchisees being the nexus?
Yes, if you read the Crinkley decision, the court looks at the franchise agreement, looks at the nexus to make a decision, and I think that the court should look at Crinkley in this case as well as all the factors that I've argued today from the franchise agreement. Thank you.
Thank you, Mr. Kennedy. Mr. Skinner.
I'll be brief fast. I know Mr. Cheney has lots of stuff to say. I do want to address the affidavit issue that Mr. Kennedy just brought up. I'd ask the court just to review those in totality. We have denied ownership in every pleading and every discovery. If you read paragraph 5, you'll notice that we deny having any place of business or own any real property or improvements in Durham, North Carolina. And in paragraph 6, the very first sentence says that all of those entities in Exhibit A are owned by franchisees. In the original affidavit, the not is in there, and in the amended affidavit, the not is a typo or scrivener's error. But if you read those in totality, the affidavit says throughout they don't own and operate. The franchisees own and operate all the businesses. They don't own any real property or otherwise. In the original affidavit, in the second affidavit, we add one sentence, and then the not got left out. But if you read all the pleadings, all the discovery, all the arguments, and the affidavits in totality, I think you'll see that it was merely a typo to leave the not out. With regard to Terry v. Cheesecake, it is not a franchisee-franchisor case. It does not mention franchisee-franchisor anywhere in that case. They merely say that after discovery, which they say is not allowed in venue arguments, but Cheesecake looks at discovery and says the RFAs admit they own property in Durham County and admit they do business. You do not have that case here. The evidence is the opposite. There's no admission that we own property there or have the same interest that Cheesecake has. The ambiguity issue that we talked about with the plaintiffs, a defendant shouldn't be left guessing what plaintiffs unilaterally notice on theirs. And if you'll look at the notice in the record, it says defendants, one apostrophe, motion to change venue to Johnston County. The only person who moved the roots to Johnston County was the Gandhi defendants. There is no ambiguity there. That ambiguity was there, also lost when they got there and said the only issue being heard today is the Gandhi's motion. So there was no ambiguity, no reason for us to stand up and say, hey, please continue. Lending Tree, I looked at it very briefly. The defendant in that case stipulated twice in the case management order and in discovery that venue was proper, and that court said, well, you can't now go back.
To follow up on Judge Gerson's question about ambiguity, it squarely is on the plaintiff, not only in the notice of the hearing, but also once we actually got there and addressed the court, and he asked, why are we here? I said, we are here on my motion to change venue, and Mr. Bibb said, that is correct. So to me, there is no ambiguity as to what was heard. It was solely the Gandhi's motion, and to the extent that that notice of hearing is ambiguous, it was drafted by plaintiff and noticed by plaintiff. I believe that plaintiff's counsel's reliance on Lending Tree is a misreading of that case, and Lending Tree does not stand for the proposition that if you serve discovery after you file a motion to change venue, you have automatically waived your venue motion. That is not what this case says. It talks about federal court cases here. In this case here, the person had participated all the way through a trial, as in one of the cases that they cited, and then they raised it. But this case absolutely does not stand for the fact that you automatically waive your venue motion if you participate in discovery. What the courts say and what Wright on procedure says in here is that you look at the actions. I mean, did they continue to pursue that motion? Were they diligent in pursuing it? And as we said, we raised it in the answer, the amended answer, the answer to the amended complaint, and the motion to reconsider. So that certainly was not waived. On the standard of review, we cited to the Griggs case. The underlying matter is a matter of law. It's a substantial right. These parties have the right to be in the right county, and it is an abuse. It is not abuse of discretion. It is a de novo review, which counsel said we didn't argue it. It's all over our brief. We argued it completely that it's a de novo review, and that's what it's. Now, if the court reverses these orders, it grants the motion to reconsider and reverses the December order, plaintiff is not harmed. Plaintiff is not prejudiced. Plaintiff is simply brought back to the commencement of the action. Now we have the record evidence. What is the proper venue for each of these parties? Johnston County for the plaintiff, Johnston County for all of the Gandhi defendants and their LLCs, and Wake County under Rule 179 for Choice Hotels. The plaintiff is protected by the law that was there when she commenced her action, and it is not in Durham County. She has lost nothing if the court allows these defendants' motions. Thank you.
Thank you very much.
Thank you.
Any more questions?
I'm set. Thank you.
No, thank you.
The case is submitted, counsel. Thank you for your excellent arguments. Mr. Sorbo.